Let me tell you a story that it's an actual experience that shows how important this is. I know you know it's already important, but you know it up here. You may not yet know it here, how important it is to be properly prepared. I didn't truly realize it either until this experience that I had. This is many years ago. I was very hesitant. I didn't want to be the lawyer that was pushing and nagging people to get their estate planning done. That's frankly not even really ethical, and I didn't want to be seen that way. So I was very hands-off, and I try to still be now, but with this experience in mind. There was a lady, just a wonderful lady that I worked with, and she, for the project that we worked together on, she would come in about once a month. She was a widow. All her siblings had passed away, her parents had passed away, and she had only one child. Okay. So I would jokingly say to her, "So you got that will done?" And she would jokingly say back to me, "No, but next time we'll get her done, okay? I'll be in next time and we'll stop and get it done." We did that for 2 years, okay? But I wasn't gonna push her on that. Now, in the back of my mind, I also made an assumption that turned out not to be right. See, here's what I was thinking. Well, she's only got one child. That's the only living relative. So if she dies, everything's going to go to him anyway. And so it's not that bad if she decided, because that's what her will was going to be. Everything goes to her son. So I thought, well, it's okay. Well, as you might imagine, the day came that she passed away very suddenly. And no, we hadn't done her estate planning. And then I learned an important fact that made my assumption wrong. You see, he wasn't actually her biological son. He called her mom and she called him son, and that's all I ever knew. But they somehow just informally adopted each other. And so here's what happened. She passed away. Her estate had to be probated. And we'll talk about what that means. But whose rules did we use? We didn't use hers because she didn't leave any. She didn't leave a will or a trust saying, "I want everything to go to my son." Even if she'd have created that will and said, "I want everything to go to him," it doesn't matter if they're related or not. It would have gone to him. But because she hadn't created her own rule book, we used the state's rules. That's the law. Well, the state's rules say if you've only got one living heir, then that heir receives it. And that's what I had planned on. But he wasn't an heir in that he wasn't related. And so we had to go back up the chain about 2 generations and then over to find someone, the next closest people that were related to her. Did they know her? Not a bit. Did they turn down the money? No way. And so her estate, which was not huge but was not insignificant, what she wanted to go to her son didn't go to her son because we didn't do the planning that needed to be done. She gave up that control. She didn't decide who benefited.